You pick up the gavel every morning, and the room stands. They stand because you represent something, the law, the Constitution, the last line between order and chaos. You have held this position for 9 years. You have a perfect record. You have never had a ruling overturned on appeal. 2 commendations from the circuit. A reputation that took 22 years to build. What the room doesn't know, what nobody in that courtroom knows, is that 3 of your last 7 rulings were decided before you ever sat down. This is how it started, and this is how it ends. Level 1, the appointment. 22 years to get here. Law school. Prosecutor's office. Appellate practice. A nomination process that lasted 14 months and involved background checks so thorough that investigators interviewed 37 people from your life, including your college roommate's ex-girlfriend. You passed everything. You were confirmed. You stood in a room and swore an oath to the Constitution. It was the most significant moment of your professional life. There are 677 federal judges in the United States. They are appointed for life. They cannot be fired. They cannot be monitored by any agency without judicial authorization. They are by design the least accountable power in the American government. You are one of them. And 2 years after your confirmation, someone found that out. The approach came at a charity fundraiser. A figure introduced through a mutual acquaintance, gray suit, careful language, a conversation framed as information exchange. He mentioned a property development adjacent to a case on your docket. He framed it as nothing more than a discussion. You knew immediately what it was. You have prosecuted cases exactly like this. You know the crime is not in the conversation, it's in whether you have the second one. You had the second one. Not because you needed the money. You make $223,400 per year. You had the second conversation because the feeling of the first one, of being specifically chosen, specifically valued in a way your robes alone didn't provide, was something you did not expect to want. And found that you did. That is the thing nobody tells you about corruption at this level. It isn't always about the money. Sometimes it's about finding out that you are in fact available. Level 2, the first ruling. The first case was chosen for you. A property dispute with a procedural vulnerability, a filing deadline missed by 3 days. You had legitimate grounds to dismiss on procedure. The ruling would survive appeal. It was defensible on its face. That is exactly why they chose it. You sat on the bench. The plaintiff's attorney, expensive suit, the specific confidence of someone who knows the outcome before the hearing starts. Across from him, the defendant's counsel, cheaper suit, very good at his job, who catches something in the plaintiff attorney's body language and pauses for 1 beat too long before his opening argument. You dismiss on procedure. 4 sentences. 40 seconds. You stand. The room stands. You leave. In chambers, your clerk brings you 2 motions for review. You sign them. She leaves. You sit in the silence of chambers for approximately 5 minutes before the familiar weight of what just happened settles on you. You pick up your gavel. You set it down. You work until 6. You go home. You eat dinner. You sleep. You wake up. You go to court. The room stands. You have discovered that this is manageable. That discovery is the most dangerous thing that has happened to you so far. Level 3, the machinery. Year 2. The cases are selected with more precision now. Not every case, they are careful. A judge who rules favorably in 53% of cases involving a specific party while being demonstrably fair in the majority of other matters does not draw attention. You are being managed. The amount has increased incrementally. The more you receive, the more expensive it becomes to cooperate with any investigation. You are being made gradually more dependent. They have read the same psychology you have. Operation Graylord, the FBI's investigation into Cook County judicial corruption between 1980 and 1987, resulted in the conviction of 17 judges, 47 lawyers, and 8 police officers. Investigators found that corrupt judges developed what prosecutors called a corruption comfort zone, psychological normalization of bribery that evolved from acute stress to routine practice. Several convicted judges stated that after the first year, the corruption felt less like a crime and more like an administrative function of their role. You understand that now in a way you didn't when you read the case files as a prosecutor. The organized crime prosecutor has been on one case for 3 years. You receive reports about her progress. You are now receiving intelligence about law enforcement investigations in addition to delivering rulings. You are deeper than you intended. You did not agree to this. You did not refuse it either. Your clerk has started watching you during hearings. Not obviously. The specific attention of someone who notices something is slightly off but cannot name what it is. You notice her noticing. You adjust. You are very good at this now. Level 4. The threat. You hesitate once. A RICO prosecution. 4 defendants, 2 with direct connections to the organization. Evidence is strong. To rule as directed, you would need to instruct the jury in a way your attentive clerk will notice is inconsistent with your established judicial voice. You consider recusing yourself. You draft the notice. You look at it for 2 days. On the 3rd morning, a figure in a plain dark coat is waiting outside your home when you leave for work. Not on your property. On the street. Not threatening. Simply present. He looks at you once. He walks away. Nothing said. Nothing needed to be said. In documented cases of judicial corruption, investigators found the most effective coercion against compromised judges is not direct threats but implicit communication, a presence, a reference to specific personal information. The absence of an explicit threat is deliberate. It creates no evidentiary record and produces the same result. You do not file the recusal. You instruct the jury as directed. It required 6 hours of case law research at 2 in the morning to find a legitimate procedural basis. 2 defendants are acquitted. The figure in the plain dark coat is not on the street the next morning. The envelope at the end of the week is the largest you have received. You have learned something. Compliance is easier than resistance. You are managed. Level 5. The collapse. The organized crime prosecutor has a spreadsheet. For the past 14 months, she has been mapping every ruling you have made against every case where the organization had a financial interest. The pattern is clear enough, combined with the financial records from accounts your intermediary thought were sufficiently layered to constitute a prosecutable case. The FBI's Public Corruption Unit uses statistical analysis of judicial rulings as one indicator of potential corruption. A pattern of rulings consistently favorable to one party, combined with financial discrepancies, has been the primary investigative pathway in multiple cases. The unit handled over 700 public corruption cases in 2022 alone. The morning it happens, you are on the bench. Mid-hearing. The doors at the back of the courtroom open. 3 figures in dark suits. The U.S. Marshals in the room shift position. Your clerk looks at you, just for a moment, before looking back at her notes. The lead agent hands the attorney a document. The attorney reads it, looks up at you. The document is a warrant. You understand everything in the 8 seconds it takes to process this. Everything you chose, everything you told yourself was manageable. Everything that is now, definitionally, over. You pick up the gavel. You set it down. You stand. For the last time in a courtroom, the room stands for you. You step down from the bench. The gavel is still on the bench. Nobody picks it up for 3 days. It sits there, the symbol of something that was sold, then taken, then left with no one to hold it. The trial is public. The evidence is read into the record. The rulings are re-examined. The defendants who were acquitted have their cases reviewed. The prosecutor who built the spreadsheet sits in the gallery and watches every day of testimony. You cooperated fully. It did not reduce the charge, only the sentence. The cooperation itself was a kind of irony, a man who sold his honesty proving his worth by being honest about it at the end. The room does not stand when you enter the sentencing. You notice. There is nothing to say. Subscribe. The next file is on the bench.